statement.
Thank you, Your Honor. May it please the court, opposing counsel, ladies and gentlemen, a business is never allowed to do anything that needlessly endangers one of their customers. That's if you're a hotel, a shopping mall, a gas station, or a gym that operates a tanning salon. You're supposed to protect your customers from needless dangers on your premises. Let's step back in time a little bit to March 26 of 2009. On that date, Fuel Fitness Center operated a gym and a tanning facility in Cedar Lake. Customers would pay Fuel Fitness to use both the gym and the tanning booths. The tanning booths were stand-up, vertical type booths. The tanning booths that they had at Fuel Fitness were built around sometime in the mid-1990s, and they were about 14 years old and were purchased used and put in that facility. They were cobbled together with different parts from what they were originally sold. In particular, the top of the stand-up booths near a vent fan had two makeshift handles for customers to hold on to tan, so that they had their arms in an upright position so that their whole body would be evenly tanned. Now, I'm sure defense counsel will be showing you these pictures. I could show them to you. You'll be seeing them plenty. So I'm not going to spend my time showing you the photographs of what it looks like in there. But at the top of this booth is a vent fan. And it's covered with a wire, circular wire, metal guard. And that is to guard people from getting into that fan accidentally. Now, when customers come in to buy time to use this particular booth, they have to sign a release that warns them about ultraviolet rays so they don't get skin cancer, or they know that they could get skin cancer. And that also, they have to sign that they can wear goggles, and they sell goggles and supply goggles. So it's kind of dark little sunglass type goggles that you would wear when you go in. No warning is given to anyone that there was a fan guard that was inadequate. In other words, that had a gap at the top where people's fingers could fit through. Now, if you look at any kind of a fan that you see in a grocery store, or they sell them at Walmart's for home household fans, they have guards so that you can't get your hands into the blade. No one looks at those guards and thinks there's some danger with them. They just realize that the guards keep your hand out of the blade. But in this particular instance, there was a big gap at the top where if you're trying to reach for those makeshift handles, and you'll see how they are, it looks like a type of a bathroom handle that you'd put a towel on or something. It doesn't go or fit there, but that's what they have. And no one would expect that you would get your hand into that guard, or that the guard would not be guarding anything. So on March 26th, Bonnie goes there. She does a workout, about a 45-minute workout in the gym, and then she's going to do the tanning. She goes into the tanning room, she locks the door, she undresses, she applies tanning lotion, she puts on her goggles, she steps into the unit, she extends her hands to reach over her head to try to find the little handholds, and all of a sudden she feels what she felt was like being electrocuted. She didn't know what happened to her. She just knew that her hand felt excruciating pain, and she just pulled that hand down. Now, you'll hear that she yelled for help. There'll be testimony of some people that tried to help her, but she was in total shock as to what happened to her. She obviously was in a state of undress. She had to somehow gather some clothes on and open the door and get help from people. At some point, she realized the severity of her injury and that her hand had gotten into the blades. She didn't know that until she was starting to get help. She was never warned that there was any danger about the guard around the fan, that it was inadequate, wasn't a proper guard. She was taken to the emergency room by ambulance. She was treated by a doctor who does plastic surgery. They did surgery on the fingers and the hands and patched them up. There was a broken bone, and she continues to have sensory problems with the fingers in terms of sensitivity to hot or to cold. She'll describe to you in detail as to how they feel. And the other concern she has is the nail had to be reconstructed. The nail bed had to be constructed. So she'll show you her fingernail, but it doesn't look like an ordinary fingernail. And because of the temperamental nature of the way that it was reconstructed, she can't use any kind of cosmetic way to make that nail look better. So who and why are we suing? We're suing Fuel Fitness Center because it needlessly endangered one of its customers by choosing to permit the customer to go into that tanning booth with the dangerous features that were in that tanning booth. In other words, odd-sized grab handles, an old used machine, and a guard around the fan that was inadequate and wouldn't protect somebody from mistakenly touching the guard. If you normally touch a guard, you think, well, the guard is going to protect me. But in this case, her fingers slipped through. And that's the kind of thing that could happen to any person that would use that particular, whether they're a teen or an adult, they could have that danger hitting them. Now, the evidence will show that Fuel Fitness had full control over the safety features that it can include in their tanning beds. As I mentioned earlier, they warned of the ultraviolet rays handles, ultraviolet ray hazard, but they didn't warn anything about the type of hazard associated with the fan. They didn't warn about the way the grab handles were placed at odd positioning, because once you're in that booth and you have the dark goggles on, you're trying to reach by feel to try to get those handles, and your vision is obscured necessarily because you're in that tan booth. And to think that these handles are going to be in different places causes you to reach around for things when you're up there. We're suing basically because Fuel Fitness was in the business of providing tanning booths, but they didn't do it in a safe fashion. They took the customer's money, but they didn't protect the customer and didn't keep them safe. They needlessly endangered them. Now, I don't know exactly what the defense is going to say. They may fault Bonnie for wearing goggles, saying that she shouldn't have worn the goggles, but they supplied goggles and they wanted you to wear them in there. They may say that because she tanned in that particular booth or one like it, there were two that are identical that had the same inadequate guards, that, well, she didn't get hurt before, it means it must be safe. I don't think you'll find that at all once you look at all the evidence. Maybe they'll say that if they had, if Bonnie had simply been going up on a ladder or somehow really tried to look at the inside of that fan, that she could have seen that the thing was inadequate. But Who would do that as a customer that thinks that they're being supplied with something safe? I know for certain that they will attack an engineering expert named Ron Houston that we had testify, and he's going to testify by video deposition. All he says is that those circular guard bars had a 1/2 inch gap at the top that would permit fingers to get through, that the grab handles were unevenly placed, and that the variance in the geometry, the way those grab handles were centered around the fan, would cause a customer to be confused and to reach to try to see, well, I've got a grab handle here, where's the other grab handle on the other side? It's not in the same spot. He also says that persons assembling a tanning booth that's used from used components should evaluate the safety of the tanning booth and the fan before allowing customers to use it. They should be careful. They should look at the dangers of the guard and the makeshift handles. And at the very least, they should provide a warning that would say, look, we've got this old tanning booth that we're letting you use. The fan guard isn't very good. Don't get your hands anywhere near that fan guard because we can't guarantee that it will keep your fingers out. For having these opinions, you'll hear Fuel Fitness challenge Mr. Houston, who has been in the engineering safety field for 50 years. They'll ask him everything that they can think about as to where he's testified in different states, but none of it makes any difference to his opinions. He's written books on the subject. He's a safety engineer, and I would just simply ask you, who was operating Fuel Fitness, the customer or the company, and who put the other in needless danger? Now, the other thing that we will be presenting in terms of evidence is evidence as to what happened to Bonnie. You'll hear about the broken finger, the lacerated fingers, the plastic surgery, the pain and discomfort, how she had to be off of work for a time, how she was embarrassed by the whole incident. She's in that tanning booth and doesn't have any clothing on, and then all of a sudden has to seek help. You'll hear about her time lost from work. You'll hear how her hand, and those fingers in particular, are sensitive to touch in cold, and she works in a deli and has to hold on to cold things, and that causes discomfort and pain in those particular fingers. It's 4 years since this incident has happened. Bonnie still lives with that discomfort and sensitivity. She still has the disfigurement, and you can evaluate what her nails look like and what her hand looks like. She has to be cautious at all times to take care of that particular hand and the nail because she doesn't want to lose it and wants to keep what she has. You'll hear how it affected her lifestyle. You'll hear testimony or information about her life expectancy. She's 49 years old at the time. She's, I think, 53 now. She's got a life expectancy of about 29 and a half years. You might be asking, well, what do I do about it, or what can I do about it as a juror? Listen to the evidence attentively. Listen to what the nature and extent of the injury is about. Listen to the emotional strain that it put Bonnie under, the pain that she had to go through. Consider the evidence of lost earnings. Consider the impact of disfigurement. And, for example, a person goes into those tanning booths because they are wanting to improve their appearance. We may think, well, gosh, not all of us want to do those tanning booths. But if that's what you're doing and you want to look better, whether it's for your family or for your own personal well-being, that is a choice. So being disfigured or not being able to look the way that she wanted to look and having the hand disfigurement is an important factor, and it's on a ring finger, and a lot of people like to display their rings or use that. So after you hear all the evidence, I will be having a chance, as the defense counsel will, to ask you what would be fair and full compensation for a case like this. So I ask you to be attentive and to give it your best efforts. Thank you.
Your Honor, we'll take just a minute to say.
Sure, go right ahead.
And notice fan that the courtroom has. All my assistants and associates have set them up. And you can get your fingers through here. I think that you'll notice, depending on where you put them, depending on how size your fingers are, that's true with most fans even today. Right here in this court, certainly is going to supply a dangerous fan. The lights down as much as you can. Sorry, we can't put the lights down any further. They're uncensored. Bonnie Martin says that she did not know the fan was there. Think about that. She says, I didn't even know the fan was there. There's no way she could not have known it. I'll show you why. She said she could not see where the handles were. Yet she was an experienced user of this tanning booth. She could have seen it looked. That's even what her engineer that they hired says. And she'll say she did not look. You will see a DVD of how to use the vertical tanning booth. Jared's in the DVD. Jared told me. To turn on the tanning booth, you must turn on the timer first. It automatically turns on a dome light in the tanning booth. It automatically turns on the fan. The fan is very loud, and you'll hear it. And there is no way that anybody could use this tanning booth and say, I did not know there was a fan there. This is basically what it looks like, and you will have pictures of it, but it's vertical, as you can see. Here's a door, here's the tanning booth lights, and over here, there's some dials, and I'm going to show those to you, and then it's hard to see in this picture, but the buttons for the tanning booth lights are in here. Now, we're on the side of it with those controls. Here's the knob where you turn the timer. Okay? That automatically turns on the dome light. Here's the dome light. Not a tanning light. It stays on all the time. And it automatically turns on the fan. Now you can see in this picture, we also have the tanning lights on. But you can only turn the tanning lights on after you turn the timer on, which automatically turns the fan on. And these are the handles Mr. Hall was speaking of. They criticize because they're different. But they're plainly there, and plainly on the other side of this booth. Now, how does this play? Do I hit something?
Just to start.
This is part of the DVD that was done to show you how to turn the tanning booth on.
I apologize. To this about,
I don't.
so it won't play.
It won't play.
No, we'll play the DVD.
The lawyer hired an engineer. The engineer said he did not give a lot of credence to her, Bonnie Martin, saying she did not know the fan was there. He said, I didn't give a lot of credence to that. He said, one would expect a fan to be there. He said, one should have heard it. He said, nothing blocked the fan and grate from view. He said she could have seen it if she looked. He agreed it was dangerous to stick her fingers through the fan grate. It could cause injury. He said she should keep her fingers out of that. Now, she was supposed to wear eye protection, but she had no problem with her eyesight. She used her own goggles, not goggles from Fuel Fitness. She tanned enough to have her own goggles. She was a regular user of the tanning booth. But she doesn't know where she got her goggles. It wasn't Fuel Fitness. She said, you can have your eyes open with the goggles on. She says, you could not see the handles through her goggles. That's what she said. We know this because we take statements before we get here. But she says she does not remember if she even looked that day that she got hurt. She said, we said, let's test them. Let's see what you can see through your goggles. She said, I threw them out. You could see where the handles were if you used the eye protection that Fuel Fitness sold. Her engineer will admit that he did no testing to determine what could be seen with the non-tanning light on, that's the dome light, with the tanning lights on, using goggles like hers, or using eye protection sold at Fuel Fitness. Her engineer will admit he never inspected the tanning booth. He never looked at it at all. He never did any tests. Who is this engineer? It's true, he's taught many years. It's also true he's hired himself out to lawyers many times. Many times. It's true he's had a lot of publications. He's published books, but none of them are about tanning booths. He is a member of a lot of professional groups, but one of his professions is as a professional witness. He makes $200 an hour to review and records, to make reports, to make affidavits for lawyers, and he knows that if he finds something in favor of the lawyer that has hired him, he will make more money because he will be able to prepare a report And if that finds in favor of the lawyer who hired him, he might get a deposition. Over 600 depositions. What is a deposition? It's when you go to a lawyer's office or a court reporter's office, and there's a court reporter there, and they take down everything that you say, and you're under oath, just as if you're in court. And he's paid to do that. Over 600. He's testified in over 250 trials. That's more trials than most lawyers ever have in a lifetime. He told me he does not know how they got his name. I had no idea. I said, well, did you ask? He said, well, it made no difference to me. Just a job. Just a way to make money. He runs a consulting business. That's his business. He taught, but he ran a consulting business, but this business never made a product. It never designed a product. He never consulted with anybody who made tanning boots. He never consulted with anybody that designed tanning boots. He never worked at a fitness gym. He never worked at a place with tanning boots. Some kind of engineer. Even though no experience with vertical tanning boots, even though he never inspected it, even though he did no testing, he gave an opinion, that it's his opinion, it was a hazard. The fan was a hazard. But I also asked him this, and he agreed, yes, I would consider any condition with potential to cause injury a hazard. Well, that's pretty broad, isn't it? I said, for example, shaving? Yeah, that would be a hazard. I said, how about drinking hot coffee? Yeah, that would be a hazard. I said, how about using sharp kitchen knives? Oh, yeah, hazard. Boiling water? Hazard. We do these every day. We do them every day. He won't be here. They recorded his video conference. I apologize because it's long and boring. But there were so many things that had to be brought out that you needed to know about his background and his failure to do any inspection or any testing to see what she could see, or if she could see, or what she knew, or when she knew it. What he says essentially is that the business should have made it impossible for her to put her fingers in there. That's not reasonable care. That's what we're here to determine. The testimony will be Fuel Fitness did not know that there was any problem with this grate. It had been used thousands of times. There had been no prior injuries and no prior complaints. Ms. Martin had used these vertical tanning boots many times. She simply didn't pay attention to what she was doing that day. They will say, adding a screen proves. What I want to talk to you about that is that after this happened, Gerald said, I never realized somebody would put their fingers up in a fan grate. But I certainly don't want anybody to get hurt. I don't want it ever happen again, even if it's their own carelessness. And so what he did was he took a piece of mesh, kind of like a screen door, and he put it inside all the grates. Okay, now, even if you're careless, it can't happen to you. But that's not the standard that you're judging by. We don't want anyone else to get hurt, even if they're not paying attention, even if it's their own fault. They're going to use that to say, well, that proves that you should have known that it was a potential hazard and you didn't fix it. What would be wrong is to do nothing once this happened. That would be what's wrong. What you do right is that, okay, this happened, let's make sure, even though it's her own carelessness, it never happened again. That's it. I wish that I could have shown you the video clip that we prepared. But technology sometimes happens. And I want you to remember this when we show this video. It's about 6 minutes. When that fan turns on, there is such a roar from that fan that there is no possible way you cannot know it is there and it is on. And her own hired engineer admits it.
Mark, we're going to need that.
Okay.
Sure, this may as well leave that.
Is that?
Yeah. Can we proceed with our evidence, Your Honor?
Yes, you may.
All right. The first thing we would like to do, and this is, I believe by agreement, we have a joint trial exhibit book, and I believe we've given a copy to the court. We would offer into evidence the joint trial exhibit 1, joint trial exhibit 2-1, which is a series of photographs, 2-2, which is another series of photographs, 2-3, which is an injury photograph, 2-3, item 2, which is another injury photograph, 2-4, which is photographs of Ms. Martin's hands, 2-5, photos of the tanning booth, exhibit 3, records of St. Anthony Medical Center emergency room, exhibit 4, records of cosmetic and plastic surgery, number 5, St. Anthony medical records, number 6, Strachan Van Til records, number 7, medical bills, stipulated, number 8, U.S. life tables, number 9, 2005 through 2009 W-2 info, number 10, incident report, number 11, defendant's exhibit 2 from an answer, number 12, lost wage computation, number 13, discovery, plaintiff's answer, second request for production, number 14, which is not a video book, but it's an actual video footage that defense counsel and plaintiff's counsel and Mr. Tomich secured at the facility, and we'll be displaying that. So those are the exhibits that are, by agreement, I believe, being offered.
Is that correct?
That's correct, Your Honor. We've stipulated to the admission of everything. I think that Dave has read off on the joint book of trial exhibits.
All right, you can pass them. Before we proceed, could you vote?